The Honorable presiding judges of the Court of Appeals of the State of North Carolina. Yes, the Court of Appeals is now in session. God save the state and this honorable court.
Good afternoon, everyone, and welcome to this remote session of North Carolina Court of Appeals. We have one case on the calendar for oral argument today, and that's number 2240, State v. Tarrance. The parties are ready to proceed, so we'll hear from the defendant.
May it please the court, I am Assistant Appellate Defender Andrew Desimone, and I represent Mr. Tarrance, and I'd like to reserve 5 minutes for rebuttal. Mr. Tarrance's mental health got lost in the shuffle of the 3 lawyers who represented him and the 3 judges he appeared before. But before we launch into the 2 legal issues, I just wanted to take a few minutes to highlight a few facts about that shuffle of lawyers and judges that might not have come across from the briefing. As you do know from the record, Mr. Tarrance wrote to the trial court repeatedly asking for help during a period of time when his first 2 lawyers had to withdraw due to conflicts of interest. He wrote about his paranoid schizophrenia and his depression and how they were getting worse. He wrote about his hallucinations and suicide attempts. When Judge Rozier asked about those hallucinations and suicide attempts, his first lawyer at her motion to withdraw hearing said, "Your Honor, I don't know what to say about that. All I can say is I've gotten written opinion from the bar that I need to withdraw." Comes the second lawyer, Alan Briones. He may never have even met Mr. Tarrance. On September 24th, 2018, and again on October 8th, 2018, Mr. Tarrance wrote to the court that Mr. Briones still had not visited him. Judge Ridgway forwarded the last letter to Mr. Briones, but he responded in saying, "I've already withdrawn due to a conflict of interest." But despite that shuffle of lawyers, Judge Rozier took these red flags about Mr. Tarrance's mental health seriously and ordered a capacity evaluation. The problem is that with that shuffle of lawyers and the oncoming shuffle of judges I'm about to talk about, no one ever followed up to make sure that the capacity evaluation happened and to make sure that the statutorily required competency hearing took place. Judge Rozier never followed up on his own order. Then a different judge, Judge Shirley, heard Mr. Briones' motion to withdraw on October 23rd, 2018, and he did not follow up on the order in the file. I want to point 2 things out from that hearing. Mr. Tarrance said on page 3, quote, "This is my first time actually in a courtroom in 14 months," end quote. Well, that was not true. He'd been in court the month before when Miss Lumsden withdrew. Red flag. Also at that hearing, the state said it had to call for special permission to get Mr. Tarrance brought over to court. The state said, quote, "because they've deemed him as a management problem, whatever that means," end quote. Another red flag. 2 more hearings happened before Judge Shirley in December of 2018, then June of 2019, and he did not follow up on Judge Rozier's order. But all of this information was in the file, all of Mr. Tarrance's letters and Judge Rozier's order. Now comes the trial and Judge Ofalu. Judge Ofalu did not follow up, even though he clearly looked in the file. On transcript pages 5 to 6, right at the start of trial, the prosecutor said, quote, "In front of you, you should have 2 file numbers," end quote. She also said that she dismissed the charge in another file, but, quote, "I left that file up there, Your Honor. There is a good deal of correspondence," and we know what that correspondence was. Then on pages 418 and pages 518, when talking about the notice of aggravating factors, Judge Ofalu said, quote, "I looked in the file. It's not in any of the files." And really, a judge should be presumed to be familiar with the court file in front of them. Yet Judge Ofalu did not inquire about the letters, and he did not inquire about Judge Rozier's order. Now comes the evidence, and he hears the state's evidence in which Mr. Tarrance told police that he suffered from bipolar disorder and schizophrenia, yet he did nothing. The colloquy, sorry, go ahead.
Excuse me, back to the pretrial facts. Do we know, there's nothing in the record, there's nothing in the briefs, but do we know whether he actually had an evaluation at Butner?
We do not. And that's a complicating factor, mostly for remedy, but yeah, we do not know.
And we do not know, so of course we can't know what the result of any such evaluation would have been.
Exactly.
All right, thank you.
Sure.
So I also have a question, counsel, about the the sequence of events here, but I'd like to understand, if I can, your interpretation of what this idea of when capacity is questioned, what that means. So I take your argument to be that it's like a triggering situation where once it is questioned, there's a statutory mandate, there must be the hearing. So I just want to ask you a pretty straightforward hypothetical and see your take on it, which is, suppose at some court proceeding, a judge says on the record, I just want to say on the record that I question the defendant's capacity. I've read the letters that the defendant has sent to the court, and I'm aware of defendant's referral to a mental health center for an evaluation I've not yet seen. So I question capacity, just want to put that on the record. And then later on in the proceeding, the parties rise and the defendant's lawyer says, Judge, I just want to point out to you, I think you were thinking of the next case. There's been no question in our case. There's no letters that my client has ever sent you, and there's never been any question about the capacity. Does there have to be a hearing in that case, in your view?
Your Honor, I think that would be the hearing. You know, that in and of itself, that colloquy to resolve the question that the judge raised is in and of itself a competency hearing. And you know, there's a continuum of what this can be and what this can look like, and I think that would satisfy it.
So suppose it wasn't that it didn't happen later in the proceeding. The lawyer sent a letter to the judge that said that later. Because the point of I think you see what I'm getting at is there's two ways to look at this. One is that it's a triggering language. The other is that it's state-based language, and the state is there is this question about capacity, and therefore when you're in that state, you have to have the hearing, which would change the analysis here somewhat, because one could interpret the sequence of events to be that the trial court no longer that the trial court believed there might be a question, but the trial court itself did not have a question anymore, and so would only proceed with the hearing if someone else gave an indication that capacity was questioned. And because the defendant and defendant's trial counsel never did that, and the state did not do that, then the statutory mandate did not require the hearing. So, you know, what's your response to that?
I'm trying to unpack that, and I think the question is, was the question ever answered? Was the concern ever resolved? Here we have an order saying, I question his capacity because of the hallucinations, because of the suicide attempts. I'm sending him, I want him to go to Central Regional Hospital and be evaluated. And then there's a part on the order that's just blank. What do we do now? That's the part about, is he competent to proceed? Is he not competent to proceed? So I think in your scenario, I'm not quite sure, but I think the question was answered, but it was not answered here.
But I guess my point is, whose burden is that? So because typically, for example, when courts have discretion to do things, or when they act in a way that's just a question of law, we presume that the court acted correctly. And here, without any indication of what was going on, couldn't we assume that whatever concern the court may have had, because of, for example, the letters and things, those concerns were resolved? And so the court was saying, if there's still a question that compels me to have a hearing, the parties will have to present that to me or to the court. And that, because that never happened, the court didn't have the hearing. And my question to you is, in that circumstance, it seems to me that would, you know, looking at Blanchard and some of the other cases, that would not be error. So I'm looking to say, where is the evidence that the court still had those concerns, and we should interpret the court's actions as meaning the court didn't have those concerns, so left it to the parties to to raise it if necessary.
Well, if you think about when the court itself questions the capacity, who you asked who should bear the burden? Well, especially in a situation where the trial court itself is raising the question, the trial court should be the one to answer that question and to follow through. I mean, who's better equipped to ensure a capacity hearing happens after the trial court itself orders an evaluation? The trial court, with all the resources of the state behind it, whose job it is to hold hearings, or a poor criminal defendant who's incarcerated and has mental health issues. I mean, it's not a close case. I think any failure.
To be fair, counsel, there's a Sixth Amendment, right? So it wasn't just the poor defendant, there was counsel, right?
There was.
Isn't it in the interest of the defendant to ensure that there's no criminal trial unless the defendant has the capacity to proceed with that? And so can't we say, well, if there was any concern, counsel could simply say, there's been a question, so we have to have the hearing, and that just didn't happen here, which is how we got to the situation that we're in.
That is one way that it could happen. I cited a case in my memorandum of additional authority, State versus Allen, and it may be. I think it's more relevant to the ultimate question of whether or not Mr. Tarrance was competent, but it can't dispense with the need for a hearing. Because remember, we don't have to show that Mr. Tarrance was incompetent at trial. We just have to show that he might have been incompetent. So in Allen, neither the defendant nor his counsel raised any concern about the defendant's capacity actually at the time of trial. There had been something about 6 months before. And so the dissent relied upon that to say that there was no bona fide doubt about competency. But the majority emphasized, quote, the decision to inquire into a defendant's competency to proceed is not shouldered solely by the defendant or his attorney, end quote. The court said that the trial court had the duty to determine whether there was a bona fide doubt. Now that's a due process, but again, these things are so interrelated, the statutory. But I want to back up a little bit.
But excuse me. Aren't the facts markedly different in Allen, though, than this case? In Allen, that defendant had been found incompetent to proceed twice already. The psychiatrist had opined they didn't see that he would ever be competent to stand trial, in part because of his intellectual deficits. And then a third psychiatrist came along and said, "Well, we think now he's competent." But then then several months passes, and then there's the trial. I mean, that's a completely different set of facts than we have before us today.
True, Your Honor. There are similarities and there are differences, but there are with any of these cases. None of them is a cookie cutter that fits right in. I mean, these are all fact and circumstance dependent because mental illness takes many forms. Another point in Allen brought up that you can't tell just from looking at someone or hearing them whether they're incompetent. I think you noted in the opinion, one forensic screener's notes actually said that you cannot tell. And in fact, even though that screener found that defendant incompetent, they said you would not have known from looking at this person that they were incompetent. But I want to make sure I don't get ahead of myself and back up a little bit. To just get back to the statute. The statute couldn't be clearer that, quote, when the capacity of the defendant to proceed is questioned, the court shall hold a hearing to determine the defendant's capacity to proceed. Here, the court itself questioned his capacity, but never held a hearing. And I think it's notable that the state did not even argue in its brief that there was no error. The state only argued that Mr. Tarrance waived this error by failing to ask for a hearing at trial.
But let me go back to my hypothetical because I just want to nail down your view on this. So suppose a court questioned capacity, but then without having a hearing, other information came to light and the court said the court no longer has any concern about capacity. And the parties then said nothing. And so the court didn't have a hearing. Is that error in your view?
I mean, that might take the place of a competency hearing because since it's a very fluid concept, that would do it if there was no concern.
But why then, if that's the case, why then isn't the state correct that some of your client's actions later, for example, sending very cogent communications about the need for counsel and things like that, indicated the capacity and resolved, and that was the hearing, so to speak. I mean, because my point is, what I'm trying to figure out is if the court here might have, because of other intervening circumstances, changed its mind essentially about the need for the hearing, having seen no further evidence that concerned it. And when no party then said, well, there's still a question, the court just determined that there was no need for the hearing because under the statute, it's only necessary if capacity is questioned, and no one was currently questioning capacity. So respond to that.
That just relies on far too much speculation about what happened. I mean, it's just a completely different scenario. You're assuming facts that we just don't know in this situation. In my mind, none of the questions were resolved, and they were only exacerbated when at trial, the judge is hearing evidence from the state that he was schizophrenic and bipolar. The judge is hearing in a colloquy that he's been taking trazodone for 2 years, a medicine used to treat depression. The judge, in sentencing him, ordered that he receive mental health treatment in prison. Judge Ofalu would not have done that unless there was a basis for questioning his mental health, which of course there was. But how could you not hold a competency hearing when that is to be viewed in conjunction with all of the letters that are in the file and the order that is unresolved in the file questioning his capacity? It's, you know, these things, like Droke said, have to be viewed in the aggregate. We don't look at one thing, laser focus in on it. It's all got to be viewed together.
But I there lots of, excuse me. Go ahead,
Judge Zachary. I'll go after you.
Well, I was just going to say, aren't there lots of mental illnesses that, from which one could suffer and still be competent to stand trial, such as depression?
Sure, absolutely. But the point is that you've got to have a trial. You know, Pate versus Robinson actually spoke to this very issue. It rejected the argument that the defendant's apparent understanding and alertness at trial can negate the requirement for a hearing. So in Pate, the Illinois Supreme Court had actually held that the evidence, quote, was not sufficient to require a hearing in light of the mental alertness and understanding displayed in Robinson's colloquies with the trial judge, end quote. The United States Supreme Court held, quote, but this reasoning offers no justification for ignoring the uncontradicted testimony of Robinson's history of pronounced irrational behavior. While his demeanor at trial might be relevant to the ultimate determination as to his sanity, it cannot be relied upon to dispense with a hearing on that very issue. Again, we don't have to show that Mr. Tarrance was incompetent at trial. It's only that he might have been incompetent at trial.
Well, what was the substantial evidence at the time of trial?
Well, the substantial evidence is that Judge Ofalu looked in the file. Even if we don't want to presume that a trial judge trying a case is familiar with the file in front of them, Judge Ofalu said he looked in the file. And there's an unresolved order questioning Mr. Tarrance's capacity and ordering an evaluation in that file.
I have a question.
Sorry, go ahead.
I got a question. So if the statute mandates a hearing once the trial court questions competency, does it matter how the defendant appeared at trial if there's been no hearing? Is that relevant to the inquiry here because there was never a hearing?
I think it's relevant, especially to the bona fide doubt due process inquiry, because that's the aggregate of circumstances that started before trial and went through trial. And you're asking, did the trial judge have a bona fide doubt about his competency? So I think
to the statutory question, do we even get to there?
No, it's not as important for the statutory.
It says trial and there was no hearing.
Right. And, you know, again, the state didn't actually argue that there was no error. The state is only saying that it was waived. But the Supreme Court issued In Re ED just last year holding that, quote, when a statute is clearly mandatory and its mandate is directed to the trial court, the statute automatically preserves statutory violations as issues for appellate review. So
don't we know that rule about statutory mandates doesn't actually apply to this statute the way it does some others? Because there's a lot of case law, including case law from the Supreme Court, that says this can be waived by the defendant, even though, so in other words, if the defendant is the one that raised the question and then waives it by not following up.
Well, first of all,
our Blanchard case is actually quite similar, it seems, to the facts of this case.
Right, but none of those cases can survive ED. They just can't. Young and Dollar and Blanchard cannot survive ED. This court should follow the most recent precedent, which is just from last year. It's already been invoked in a number of different scenarios. So the state actually cited a case in its memorandum that supports our position that the statutory claim here is preserved for appellate review, which perhaps the state will now concede. In State versus Hamer, the Court of Appeals relied upon INRED and unanimously held, even though it was a split decision, unanimously held that the violation of the statutory mandate in that case was preserved for appeal, even though the defendant did not object. The same has to be true here. And I want to make one other point about INRED because our Supreme Court quoted its earlier decision in State versus Hucks, the one about requiring the statute requiring two defense counsel in capital cases, and recognized that the statute there, quote, neither expressly nor impliedly placed any responsibility on the defendant to ask for assistant counsel, end quote. The exact same is true here as to the statutory mandate for competency hearing after capacities question. The statute places the sole responsibility for holding a hearing on the trial court and places no responsibility whatsoever on the potentially incompetent criminal defendant, which makes sense.
But let me go back again, and I'm not trying to keep returning to the same issue, but suppose there was evidence so that if an appellate court might look and say, well, there was what we believe was serious questions of competency here in this trial record, but it never came up. The parties never mentioned it. The trial court never mentioned it. That issue couldn't be raised for the first time on appeal on the grounds that there was a statutory mandate. Would you agree with me with that? Because the mandate has this language, it's questioned.
Right.
The capacity is questioned. So suppose we conclude that whatever question the trial court had, it didn't have anymore. And that's why I never had the hearing, and thought if someone else wants to question it, put it back into question. They need to raise that. Isn't the best way to resolve this then to let it be an ineffective assistance, MAR, where there can be an evidentiary hearing that tries to recreate this, what's not in our record, this information from the evaluation, and whatever other information, for example, an expert may have in speaking to your client about capacity at that time, and then make a determination about whether there's any reasonable probability that the result would have been different. That is, that you would have been found not competent to be tried. Well, why isn't that the best result here?
I disagree because first it's speculation, but second, the speculation doesn't even, if you look at what actually happened, Judge Rozier questioned his competency and then Judge Rozier was out. This was, the way we do cases here is unfortunate. Sorry.
Excuse me. Actually, didn't the defendant raise it first? He filed I know he was represented, but while he was represented, he filed a pro se petition, right. which is what actually brought it to Judge Rozier's attention, I believe.
That's true. That's true. He's asking for help.
We keep talking about this as if Judge Rozier raised it initially, and it seems to me that actually the defendant raised it.
You're absolutely correct. The defendant is asking for help and telling the court that his mental health is going downhill fast. And Judge Rozier then, issues that order. If you look at record pages 33 and 34, that's the order, and it literally says his capacity, quote, check mark, is in question. And that is what Judge Rozier is doing. And that's why I was speaking that Judge Rozier is the one, because I'm viewing it as Judge Rozier in this instance is the one triggering the requirement for the hearing. But
again, isn't the problem here that if your client had said, I agree with you that if your client had said, have the hearing. It's in question, have the hearing. And the trial court said, no, not having the hearing. That's absolutely a violation of this statutory mandate. And if there's no further preservation, you can raise that on appeal. But the problem here is without that indication, there is a way to synthesize the past precedent with this statute with the statutory mandate precedent. And that is to say that because it's a state-based inquiry, if the court changed its mind and the court wasn't putting it in question and the parties chose not to put it in question, then the matter passes and there's no need for hearing.
But remember, Judge Rozier only had that one pretrial hearing and then was out of the case. He had no opportunity to dispel any question that he had. I mean, there just wasn't an opportunity for that. That's the way, unfortunately, our system works, is that we get a bunch of different judges. It's certainly not the defense's preferred way of going about it. But I think to have your analysis, you'd have to read something into the statute. You'd have to read an additional question into the statute, and it's just not there. When capacity is questioned, the court shall hold a hearing. And I think it's an even stronger case when it's the court itself questioning capacity. We're not asking for a broad holding here. This could be a very narrow holding. When the court itself questions capacity, the court shall hold a hearing. It just has to. I'll reserve my remainder of time for my rebuttal, if that's okay, but I'm happy to answer questions first.
I'm fine. Go ahead.
Sorry, I was muted. I'm muted. Well, we'll hear from the state.
All right, are we ready? All right. Thank you, Your Honors. May it please the court. My name is Casey Hunt. I'm a Special Deputy Attorney General with the North Carolina Department of Justice, representing the state of North Carolina in this matter. Your Honors, there is no question that a defendant has to be competent to stand trial. In North Carolina, this fundamental principle is protected in two ways, which we've been discussing. Once is via statute, essentially 15A 1002, that says when the question of competency is raised, the trial court must hold a hearing. And the other via the due process protections of the 14th Amendment, which say that a trial court must sua sponte institute a competency hearing if there is either substantial evidence of incompetency or a bona fide doubt as to competency. Mr. Tarrance is certainly entitled to boast of these protections if they're applicable, but here he waived his statutory right to a competency hearing, and there simply wasn't substantial evidence of incompetency or a bona fide doubt as to competency when it comes to Mr. Tarrance standing trial. When we look first at the statutory right to a competency hearing, it's kind of a two-part thing. One, if the question is raised, then the trial court has to hold the hearing. And going to what Mr. DeSimone and I believe Judge Zachary, to your question about, does it matter particularly that the trial court's the one that filed the motion? There is no weight either by a statute or by a case law to who actually brings the motion questioning competency. A motion is required by the statute. If you look at 15A 1002 subsection A, where it says the question of capacity of the defendant to proceed may be raised at any time on motion. So more of a perhaps procedural check mark when you point out that in May of 2018, a defendant himself filed this pro se petition for mental evaluation despite being represented at the time. When we go to the September 5th hearing, which was the impetus for Judge Rozier's September 5th motion, at that hearing, defendant's counsel is allowed to withdraw. Defendant then gets up and speaks and addresses his mental health concerns, addresses the petition that he filed. And at that point, Judge Rozier, looking at a pro se defendant at that point, says, let me take a look. And if, there's a question, I'll get a motion filed. That's what brought about the motion. So when it comes to who actually raises the question of competency, when we're looking at the statutory scheme for a competency hearing, there's no weight given to who does. And I think that's appropriate. The statute says it can be the prosecutor, the trial court, the defendant, or defense counsel. And I think it allows either of these parties to raise the question of competency when appropriate and when they feel like they should, without any repercussion that down the line that might affect some sort of legal argument about defendant's competency.
And just to be clear, at this point, there is a motion, correct, to question competency. So that's regardless of who raised it, correct? And then there is an order by Judge Rozier for an evaluation. So, so it's been raised and there's an order to get an evaluation.
That's correct, Your Honor. There's an order directed to two parties, really. One is the sheriff to transport Mr. Tarrance to Central Regional Hospital, and the second part of the order is directed to the director of Central Regional Hospital to submit a report back regarding defendant's capacity to proceed.
So, counsel, if that report had come back and it had said competent to proceed to trial, and then in light of some of the other things that happened later in the case, such as the defendant's communications about counsel, needing counsel, and things like that appeared very cogent, then I think you'd have a stronger argument. But I mean, isn't the problem here that we just don't know what happened there? And so the last thing that we can see from the trial court was questioning capacity. In fact, using exact words, capacity is questioned, right? But there was no hearing. So looking at the statute, it seems like this is a pretty clear violation of the statutory mandate. So how do you get around that?
So, Your Honor, two things I'll address. I believe what the second part of your question was. First, it's a violation of the statutory mandate. There's no question a hearing wasn't held, but it's a waivable right. And that's what we have to get to. Kind of going to the scenarios you were presenting before about, say, that the trial court had a question and then didn't have a question, but then defendant or defense counsel never raised the issue of a hearing. That goes to waiver. That could definitely be considered waiver in that point because it's a failure to assert the right. And that's one of the three ways the defendant can waive the right to the statutory hearing under State v. Young. When we look at the fact that there was not an evaluation, violation of a court order, failing to comply with the court order, perhaps, certainly not an ideal situation. But when we look at the statute at 15A 1002, and we see, first of all, there doesn't have to be an evaluation to have a hearing. It just says if the question is raised. What the evaluation does, it really has two effects on the hearing, and this is all in the statute. One is that it's admissible at the hearing, so certainly would go towards, the evidence and weighing the evidence of competency if the hearing was held, if Mr. Tarrance hadn't waived his right to the hearing. And two, it affects the timing of the hearing. If an evaluation is ordered, then the hearing cannot be held until after the evaluation comes back, the report comes back. So those are the two things an evaluation really does when it comes to the hearing. Obviously affects which evidence is admissible or admitted at the hearing, and then two, the timing of the hearing. But the fact that there's not an evaluation, like I said, perhaps an issue with failing to comply with the court order, but there is no statutory right to that evaluation. And any issues with the court order or failing to comply with it should have been addressed at the trial court level and weren't brought up on this appeal. I also wanted to address, while I was about to talk about defendant's waiver of his statutory right, Mr. DeSimone brought up the In Re ED case. In Re ED does not go to waiver of a statutory right. That is not what the case addresses. It addresses the overarching issue of when a trial court's violation of a statutory mandate is preserved for appellate review. And then on appellate review, the appellate court can consider waiver as part of the arguments. But and In Re Hamer actually clarifies that is what In Re ED does. It essentially takes that general rule of preservation for review, which is that if a trial court violates a statutory mandate and defendant is prejudiced, then defendant doesn't have to object at the trial court level to have it preserved. It's automatically preserved. In Re ED kind of takes that statutory mandate and clarifies that it's a statutory mandate directed to the trial court. So it would kind of rewrite the general rule to say, when their trial court violates a statutory mandate directed to it, and the defendant is prejudiced thereby, there doesn't have to be any action on the part of the defendant at the trial court level. So the state has never contested that this issue is properly preserved for appellate review, and In Re ED simply doesn't go to the issue of waiver of a statutory right.
Counsel, one thing we heard from your friend for the defendant was that, well, that all may be true, but the distinction here is that the defendant, of course, could waive, and in our appellate review, we could determine that there'd been some waiver at the trial level of some issue that the defendant should have been asserting. But here it was the trial court, not the defendant, was the one that questioned capacity. And so only the trial court then could, so in my hypotheticals, for example, where the trial court sort of withdrawing that question, only the trial court could do that. There's just only speculation about why the court never had the hearing, no actual evidence. So we just or at least your friend for the defendant is arguing, we can't assume that the reason is the court withdrew that capacity question, and the defendant can't waive that because it was the court that raised it. So what's your response to that?
Your Honor, the defendant can waive it. There is no weight given to the fact that it was actually the trial court that raised the motion. As is in the record, I believe it's page 29 is that petition, the defendant's pro se petition for mental evaluation. So arguably, was that raising the question? I think looking at the formality of the fact that on September 5th, Judge Rozier entered the motion, because the statute requires a motion, and to kind of check that procedural box. Neither the statute nor the case law say that that is given any particular weight, that is in the trial court that has to ensure that there's a hearing, any more than say if the prosecutor had filed the motion. There's nothing that says the prosecutor then has to make sure that there's a hearing, and that goes to because defendant is able to waive this right. And in State v. Young, he can waive it via, express consent, obviously, but he can also waive it simply by failing to assert it or, kind of engaging in conduct that's inconsistent with asserting it, which is exactly what we have here. And when we look
let's assume for argument that we determine that either he didn't waive it or he can't waive it. Was the statute violated?
In that case, then there wasn't a hearing. It's a statutory mandate, and there was not a hearing.
And then what's the remedy for that?
The remedy, Your Honor, the case law says that the remedy for that is a new trial, except in this case, there's also the issue of prejudice. In State v. Hamer, it discusses that a new trial does not necessarily follow a violation of a statutory mandate. That defendant has to show both the violation of a statutory mandate and prejudice. And in order to show prejudice, we look at the standard under 15A 1443. And here, there aren't even anything in the briefs about prejudice. There certainly hasn't been any evidence or argument presented about that. And so if that were the case, Your Honor, and then this court decided that defendant did not waive his right to the statutory hearing, it would essentially be a case of perhaps there was a violation of a statutory mandate, but their defendant's not entitled to any relief. And when we look at
excuse me, but in Allen, didn't we remand for a competency hearing?
Yes, ma'am. In State v. Allen, there was a remand for a retrospective competency hearing, and that one was an interesting one. But it also, in State v. Allen, that's dealing with the constitutional argument, the constitutional side, the due process right to a competency hearing, and not the statutory right to a competency hearing. So when we look at the potential remedies on the due process side, there are two remedies. The State v. Ash establishes two remedies: a new trial or a retrospective competency hearing.
And can you talk for a moment about how, in this case, we could have a retrospective competency hearing? How does that happen when we have no even evaluation?
Certainly, Your Honor. When we're looking at a retrospective competency hearing, the reason why that would be an appropriate remedy here, particularly, is because it actually preserves both potential remedies. When you remand for a retrospective competency hearing, it's kind of a two-part evaluation. First is the trial court considers, can I even hold a retrospective competency hearing? And there's two McCrae cases that have been cited, a 2000 case and a 2004 case. So McCrae 1 and McCrae 2 both say, and Ash as well, that the trial court is best able to determine whether it can hold a retrospective competency hearing. If it cannot hold one, then the remedy is a new trial. If the trial court says, yes, we can, then the retrospective competency hearing is held, and then depending on the finding, kind of go from there. And here, as defendant points out in defendant's briefing, is that we don't have an evaluation though. But that's okay, because we can look at a case like State v. Allen and say, in Allen, for example, there's an extensive history of mental illness, some cognitive disabilities, and other issues like that. And there was some, perhaps not a true question raised at trial, but defense counsel certainly didn't seem to be comfortable with the idea that Allen was competent. And there was a demand for a retrospective competency hearing. But what we don't have there is a timely evaluation. The last evaluation of defendant in the Allen case was done 8 months prior to trial. And here, in Allen, there was no evaluation at the time of trial. And when we look at the due process competency hearing rights, that is a present ability to stand trial. We don't look at all the historical stuff as much. We don't look at just the past history of defendant having a mental illness, and State v. Badgett and State v. King talk about that, but the past history is not enough. We're looking at present ability. And in Allen, when that was raised, they're remanded for a retrospective competency hearing without an evaluation. So here, that would be a very similar situation. And while we're on the Fourth Amendment constitutional side, with that one, that right is triggered, the trial court has a sua sponte duty to institute a competency hearing if there is substantial evidence of incompetence or a bona fide doubt as to competency. And here, Your Honors, when we're talking about that constitutional right for which a retrospective competency hearing is a remedy, there is really no question about that at trial, at the time of trial, that there was any substantial evidence or bona fide doubt as to defendant's incompetency. We can look at, first of all, the fact that defense counsel didn't raise any questions at the time of trial about defendant's incompetency or perhaps lack of competency. And because defense counsel is usually in the best position to know if a defendant is competent, courts really look to whether defense counsel disputes competency as evidence of competency. And that's in the McCrae 2 case, it talks about that. Not only did defense counsel not affirmatively raise the issue of competency at trial, but the trial court gave defense counsel multiple opportunities to raise it. At the beginning and end of each day of trial, the trial court said, do you have any motions? Would you like to be heard on anything? And defense counsel always said no, didn't bring anything up. And then on the final day of trial, just at the beginning of the day, the trial court again asked, do you know anything to be heard on? And the answer was no. So defense counsel didn't have any concerns or didn't raise any concerns at the time of trial. And we're looking at that present ability time of trial analysis under the constitutional right. So we can also look to, obviously, defendant's behavior and his testimony at trial. His direct and cross examinations, the transcript, page 421 to 447, he's respectful, he's coherent, he's responsive, what you would expect of someone on the stand at a trial. Same thing with the transcript of plea, pages 527 to 32. He says he has his GED, 12th grade education. He does acknowledge that he's been on trazodone, but he's been on trazodone for 2 years at that point. And then at sentencing, pages 542 to 43, defendant speaks on his own behalf, again, respectful, responsive, coherent. There was also a point in time when the jury was deliberating, and this is the transcript, page 521, where Mr. Kelly, his defense counsel, they're discussing whether or not defendant will plead guilty to being a habitual felon if the jury returns a guilty verdict on the indecent liberties charges. And while there's no testimony from defendant himself at this point in the transcript, Mr. Kelly says, I've already talked to my client about this, but let me have a little sidebar conversation with him, which obviously is not included in the transcript. But Mr. Kelly comes back and says, yes, defendant intends to plead to being a habitual felon if the time arises. So it shows defendant engaged with his attorney. Obviously, his attorney feels like he can talk to his client about what's going on and get his input, and he understands what's going on. So, Your Honors, when you take all of this under the constitutional analysis of is there substantial evidence of incompetency at the time of trial or a bona fide doubt as to competency, there's simply nothing to raise a concern. Everything that the defendant has pointed to is all past history of potential mental illness. We have State's Exhibit 18 was admitted at trial, where defendant discusses concerns about paranoid schizophrenia and bipolar, but that is a video from August of 2017. That is a video of defendant being interviewed when he was arrested. We look at—
I have a question. I'm sorry. So when we talk about either substantial evidence or a bona fide doubt, correct? It's in the disjunctive. So it seems to me that the evidence that you've talked about is the bona fide doubt, what's before Judge O'Flew. But it seems like the substantial evidence prong, you would look at perhaps what is in the file. Am I not correct about that?
Your Honor, so when we look at the bona fide doubt, I think when you look at State v. Badgett and State v. King, that bona fide doubt can't be based on past history of mental illness. And everything that is in the file is a past history. So I don't think it rises to a level of bona fide doubt. And when you look at the substantial evidence question, we also have to remember that there was no evidence presented at trial about this. Everything we're talking about was in the court file. It was not presented as evidence or testimony at trial. And so, and all of it's past. It goes from August of 2017 to, at the latest, you could say October of 2018, which was almost a year before trial. And the constitutional side of a competency hearing goes to that present ability. And State v. Badgett talks about that. And I believe Badgett is quoting Dusky when it's discussing it. But we're looking at defendant's ability to stand trial right now.
Okay, so regardless of how much is in the file in the past, your argument is that it's solely the judge's perception of how the defendant looks at trial that would create the bona fide doubt?
No, Your Honor, not at all. I would agree that it can be difficult and at times probably impossible to just look at a defendant and see if a defendant is incompetent, but that's why the question has to be raised. That's why defense counsel has to say something. That's why there has to be evidence or testimony at trial, saying, hey, defendant has a past history of this. In this case, we actually don't even have I would call it a medically supported past history. Everything is just statements defendant has made. When we look at the cases where, say, for example, Allen or State v. Whitted, State v. Staten, kind of those cases had evidence that went towards the constitutional analysis for competency hearing was presented at trial, even past evidence of potential mental health issues. So, I guess you're relying on the trial court judge's perception of a defendant. Of course, that's one part of an analysis, but if there's simply nothing before the trial judge to question competency, there's some stuff in the file, but there's no evidence or testimony admitted to show a present day potential issue with competency, that's what, for the constitutional analysis, that's what the trial court judge works off of. And so, Your Honor, when we go to that, we see that there is no substantial evidence and no bona fide doubt based on what was presented at trial, then the trial court didn't have this sua sponte duty to institute the constitutional competency hearing. And when we look at, okay, well, in the time period preceding trial or even at trial, we go back to the statutory right. That kind of protects everything else. When you can bring up this question of competency, there's no limit as to the number of times competency can be questioned under 15A-1002. It said there's no weight given to who brings up the question of competency, but that's defendant's right to a hearing, though, and defendant has the ability to waive that right. And so when we look at it here, like I mentioned before, State v. Young is the case that talks about defendant's ability to waive that right. And then we look at, I'm sorry, I thought I heard something. When we look at what defendant did in this case, did defendant waive his right to this statutory hearing? And the answer is yes, because again, defendant's counsel never brought up the question again. They never filed another motion. They never said, hey, trial court, there was this order for a competency evaluation. Do we need a motion to show cause? Do we need a motion to compel? We need something because it hasn't happened.
I have a question about that. So after the order was entered, was there ever any correspondence from the defendant saying, hey, wait a minute, I was supposed to have this evaluation. That hasn't happened yet. That's in the record, isn't it?
Well, actually, what's in the record, the 3 letters that defendant wrote in September and early October reference back to his petition. My reading of those letters, it seems like defendant may not know that the motion and order were entered, because in those letters, I believe, my recollection is that he's essentially saying my counsel hasn't communicated with me enough and expressing concerns about that to Judge Ridgway, and then also essentially inquiring as to the status of his petition. So I'm not sure if that was just a reference error on the part of defendant, but it doesn't seem like defendant ever particularly knew or at least referenced the actual motion and order.
Okay, so if we would interpret his letters as an understanding that he was supposed to go and get an evaluation, but hadn't been given one yet. Would that go to his waiver? And in fact, show that he didn't waive it?
It doesn't go necessarily to the waiver of the statutory right to a hearing. It certainly would go to whether or not the director of Central Regional Hospital complied with the court's order, which is, another issue that could have been addressed at the trial court level, but simply wasn't. But I believe that's what it would go to, Your Honor. And when we look at other opportunities defendant had to assert this statutory right, even post this September-October 2018 timeframe, we look at, there was a hearing in October of 2018, also a motion to withdraw hearing. And at that hearing, defendant spoke at length with the trial court and discussed concerns he had about discovery in his case. It discussed concerns about the results of the rape test kit that came back. Defendant requested dismissal. He also brought up his right to a speedy trial. So certainly at this October 2018 hearing, defendant is showing a true understanding of his case and the nuances of his case. But he doesn't bring up the competency question. We look at December 2018. That was defendant's arraignment. He was in court. He didn't speak. It was pretty short, just like an arraignment typically is. But again, neither defense counsel nor defendant brought up, hey, I haven't had my evaluation. Hey, I haven't had this hearing. We look at the June 2019 motion to continue hearing. That was the original, on second original trial date. But that defendant and defense counsel spoke. Again, didn't raise any questions about competency, the fact that there hadn't been an evaluation and hadn't been a hearing. And then we look at the trial, which is I've already kind of walked through. There was no question raised whatsoever. Even despite the trial court's affirmative statements of, do you want to be heard on anything? Anything you want to discuss with the court on at least 7 different occasions, beginning and end of the first 3 days of trial and the beginning of the 4th day of trial. And Your Honors, all of this supports, when we look at the standard under State v. Young for waiver of the statutory right to a competency hearing, the defendant waived it simply by failing to assert that right, because it is defendant's right. And we can look at State v. Dollar discusses waiver, State v. Ash. State v. Sides is another interesting one, because mainly State v. Sides was decided after the decision in In Re ED, and State v. Sides discusses waiver of the statutory right to a competency hearing, which also goes to the fact that In Re ED doesn't supersede waiver cases. The Court of Appeals has already considered waiver post In Re ED in this context. And so, Your Honors, when we look at these cases, when we look at Dollar and Young and Ash and Sides, we see that what happened here is that defendant waived his right to a statutory competency hearing. And when we take the 2 ways that defendant's competency is protected, both by the statutory right to a competency hearing, the question is raised, and then via the constitutional due process, the trial court has a duty sua sponte raise that issue. We see that defendant waived his statutory right to a competency hearing, and that there simply was never substantial evidence of incompetency or a bona fide doubt as to competency when it comes down to defendant's behavior and what was known at the time of trial, which is when that constitutional analysis has to take place. So, Your Honors, unless you have any other questions, the state will rest on its brief, and just we believe the holding should be defendant waived his statutory right and the constitutional duty of the trial court never arose. Thank you very much.
All right, thank you. Any rebuttal?
Yes, please. Thank you. Now, the state said that any error was not prejudicial. Competency is just completely different. Because if there had been a competency hearing, there might not have been a trial at all, and Mr. Tarrance would not have had these convictions. So that satisfies any standard of prejudice you would want to apply. You could even assume arguendo, any particular standard, and this meets it. With that said, I think this type of error in not holding a competency hearing is structural and really not subject to any kind of harmless error review. Take Peyton Drope, for example. After finding error and failing to hold a competency hearing, the Supreme Court did not analyze the harmlessness of the error. Rather, the court only addressed the appropriate remedy. They had to decide, was a retrospective competency hearing feasible? After they determined that it was not, they reversed the convictions and remanded for new trials. And that's also why I cited Cooper versus Oklahoma after the state, cited that case in its memorandum. In Cooper, the court came right up to the line of saying this is structural error. The court said the importance of the rights and the decisions involved demonstrates that an erroneous determination of competence threatens a fundamental component of our criminal justice system, the basic fairness of the trial itself, citing United States versus Chronic, a quintessential structural error case. But again, it really doesn't matter which prejudice lens you use, because failing to hold a competency hearing when it's required is prejudicial under any standard.
Counsel, to Judge Zachary's question, do you think we have the authority to remand for the trial court to determine if it can conduct a hearing, a retrospective hearing, then based on that determination, follow up with the hearing, and then from that result, whether there's a trial or not? Do you think we have the authority for that under our case law?
Yeah, the issue of remedy is complicated because we don't know whether he was ever evaluated. If he was never evaluated under the case law, a new trial would definitely be the most appropriate remedy. Like this court said in Ash in 2013, where competency was never assessed, let alone at a relevant time, a retrospective hearing is impossible, so new trial. But even if he was evaluated in October or September of 2018, that was 9 or 10 months before trial at the end of July 2019. So really, it would be extremely difficult. So he should receive a new trial. But if this court is not inclined to do that, then yes, this court should at the very least send it back. The judge can make that determination. Can I now do a retrospective competency? Can we, if he was he evaluated, can we get that? So that would be appropriate. The state also said that there was that bona fide doubt can't be based on past history, and that's just not true. Bona fide doubt, like Trump says, is the aggregate of circumstances. And here, that just can't be detached from what happened at trial, because the judge had the file, said he looked in the file, it's right there in front of him. The things that then happen at trial, hearing the evidence about his mental illness, having a colloquy, hearing he's taking medicine for depression, hearing and then ordering mental health treatment for him in prison, which must mean, that's just, judges don't do that as a matter of course. There had to be a basis for that order. So considering all of the circumstances, the trial court deprived Mr. Tarrance of due process. And the state continually relies on State versus Young and Dollar, but they are just not good law anymore after In re D. I just don't see the distinction that the state is attempting to make here. It just doesn't doesn't fly. It's either wait for appellate review or it's not. And In re ED says it's not. So those cases are no longer a good trial. So just because of all the indications that Mr. Tarrance may have lacked capacity, this court should not have confidence in the integrity of these convictions. So I respectfully ask this court to order a new trial, or at the very least, a retrospective competency hearing.
All right. Thank you, counsel. Thank you to both parties for your arguments. And we will adjourn. Mr. Horn?
This session of the North Carolina Court of Appeals is now adjourned.
Thank you all.
All right. Thank you, counsel. You're free to drop off now.